And on behalf of the Department of Civil Engineering of Hindusthan College of Engineering and Technology, Coimbatore, I take immense pleasure in welcoming you all to this webinar on intellectual property rights and patent process. And this is organized in association with Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, and IPR Club of our institution. Well, intellectual property rights are the exclusive rights given to persons over the creations of their minds. And when a business or an individual has some idea that they want to protect from being used by others without their permission, it is best to seek legal protection of that intellectual property. And by seeking property rights over your intellectual property, the property that is the creation of the mind, which could be an invention, symbol, or even a name, you establish rightful ownership and prevent the unlawful use of your property. Have amidst us an eminent personality with profound knowledge and wealth of experience in the area of intellectual property rights and patent process, Dr. Bharat N. Suryavanshi, who is the Assistant Controller of Patent and Design from Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. He completed his bachelor's in science from Chenna Basaveshwar College, Balki, and master's in science and MPhil from Gulbarga University, Gulbarga, Karnataka, PhD from Swami Raman, and third Marathwada University, Maharashtra. And to his credit, he has many research papers published in reputed journals and conference proceedings. He joined as examiner of Patents and Design Group A in July 2003 in the Patent Office, Mumbai, and was promoted as Assistant Controller of Patents and Design in December 2012. He has attended many training programs in India and abroad and has delivered a number of lectures in IPR in many institutions, companies, including Biotech Consortium India Limited and so on. He was instrumental in the rejection of Pfizer's patent application for rheumatoid arthritis drug, which hit the headlines in 2015. And the major reason stated for the same was that the drug did not enhance the efficacy of the existing approved drug. With these words about the speaker, I take this opportunity to welcome Dr. Bharat to enlighten the participants on IPR and the patent process. And I would also like to thank him immensely for immediately accepting our request and invitation to share his expertise in intellectual property rights in this webinar. Thank you so much, sir. And the
Thank
session
you.
is yours. Forward. Thank you, sir.
Okay, good afternoon to you, everyone. Warm welcome to the IPR session. Now I'll deliver the different intellectual property rights, even patents, design, copyrights, and geography indications, how they are interlinked, and how to file the patent application with respect to different kind of examples. Okay, I'll present my slides now. Are you able to see my slide?
Sir, yes, sir. Yes, it's getting us.
Okay, okay.
Yes.
Is it fine?
Yes, sir. Yes. Sir, if it is full screen, it is very convenient, sir.
Just a minute. Okay.
Yeah, fine, sir. Fine.
Yeah. Now, as we are all well known about the different kind of intellectual property, as we are in India's science graduate, we know what is design. Even though in detail, I want to explain you regarding the different kind of intellectual property with respect to our organization where we fall. As we are working under the Ministry of Commerce and Industry, Department for Promotion of Industry and International Trade, wherein our Office of the Control General of Patents, Design, Trademark and Geography Indication, where we are having different kind of patent offices located at 4 locations: Kolkata, New Delhi, Mumbai, Chennai. Where is PIS means Patent Information System, that is called Rajiv Gandhi National Institute of Intellectual Property Management, Only one center in India located in Nagpur, wherein we are having national and international training with clubs to WIPO and other different countries. Trademark offices are located at Mumbai, Kolkata, New Delhi, Chennai, and Ahmedabad, wherein only trademarks work is carried out Ahmedabad, that is the additional office located. Appellate board is in Chennai and also a patent office in Chennai for that. This is a pictorial view of our offices, Mumbai, Delhi, Chennai, and Kolkata. This is our training center wherein we are having all the trainings to the this thing. This is our official website wherein you get all the information regarding patents, designs, trademark, and geographical indications, where you are able to get forms, information, and fee structure where you are able to file the application. So, any doubts, any queries, you can go to www.ipindia.go.in. You can get all the solution to the forms which are able to file the patents, designs, and trademark also. What is intellectual property? It's a product of mind, because any solution for a problem which are existing in the nature is originates from the mind. Therefore, that is intellectual property. For example, we are having facing day by day problems that may be in the field of science, common public places, and also everywhere. So, for example, at present we are facing the COVID-19 problem. If any scientist or a common man is while discussing in the classroom or in the public domain or wherever he sits, if he thinks about the solution for that is nothing but a product of his mind. That is called intellectual property. As we have seen, many people are thinking if we eat herbal kadha, that is extract of all the medicinal ingredients, medicinal plants, somebody says we'll get rid of respiratory tract problem. That is nothing but a solution. But how much it is novel, inventive, that is up to the when we search in the database. But actually something idea comes to your mind that may patents, design, trademark, or copy, that is intellectual property, that is product of mind. For example, we are having a problem of gases. What we cooking gas, what we are using in the home, since long time we are using. But every time if you want to book the next gas, we always lift our cylinder and we see how much gas is remaining in the cylinder. What is this? Still again we are following the conventional route to see the amount of gas remaining in the cylinder. So nobody thought of the solution. If somebody comes with by knowing the conventional problem in the daily house or in the community, somebody if comes to a knob which indicates the gas, how much remaining in the cylinder, that ultimately solves our problem. That is nothing but a problem to a solution. The problem was there, you are finding solution. That is nothing but your intellectual property, because you are doing some knob design and something technology which in order to indicate the gas pressure, how much remain in the cylinder. This is a solution for that. So somebody might have thought and also got patent for, but still we are lifting the gas and still not using in the home. This is nothing but a problems, and we are supposed to solve by thinking or discussing in the group or somewhere, so that each and every problem of our home related or office related or even in the industrial related or in the environmental, we can come to a solution. For example, we are having a lot of wind. If you are converting wind energy into electrical, that is something technology, but already is there. If something improvement you are doing, that is nothing but a improvement over the existing. Once the property means, it comes to our mind that we are having a which is purchased or exchanged by the currency. That or ultimately spent, that is car, gold, house. It comes to our minds. That may be different kind. That may be tangible and intangible. Doesn't matter. Mobile, car, immobile building. So these are different kind of property, but property means in our common man minds comes same car, buildings, gold, this and that. It's not. It's another kind of property that is called intellectual property. In this, we are having copyrights which is directly originated from our mind. Another one is industrial property, wherein it can be made used in the industry. That is called industrial property, wherein patents, design, trademarks, and geography indication. Let us see one by one what is patents, design, and other properties. What is intellectual property? It's a intangible creations of human intellect having commercial value and asset like any other form. What is this? Intangible creations of whom? Human value. Something you are creating from your this thing and which has commercial value. By licensing or by giving somebody, you are getting royalty that is called intellectual property. Intellectual property rights are exclusive right, territorial right, and licensable right. Why it's excluded? Once you get a patent, it is exclusive of your own. You can give by licensing. It can also called as negative right because other people will not excise the patent what you have got. Why is it general right? Because once you are filing a patent application in India, it's valid to India only. If you want to file in other countries, like conventional countries or Japan, USA, other countries, that is through PCT, Patent Cooperation Treaty route. That is, therefore, patent is a territorial right. And it is a licensable right because once you get a patent on your name, you can license to anyone on the basis of royalty and you can earn like anything as a other form of the property. Therefore, it's called a asset like any other form of property. What is the significance of intellectual property? It's avoid duplication of research. For example, you are sitting in Coimbatore, I am in Nagpur. Same civil engineer is working on gypsum cement and composition of that. It doesn't worth by spending the money or our value or our time or our intellectuals in doing the same research because we are being a one country we are supposed to more research as compared to other countries wherein filing of Indian patents in civil department is very less as compared to other departments in other countries. Therefore it's avoid duplication of research. Therefore you are supposed to file a patent application so that by knowing the data from the patent office website, other co-workers or other researchers who are in the same field will not repeat it. Encourage the creation of wide variety of intellectual goods. By knowing, you can create a lot of goods which are new, which are in the market that will be different kind of designs, different tools, or different machines. Help industry to improve existing technology to produce better and cheaper goods. Here, for example, we are knowing already we are having many technology in the market, for example, electric bulb. Now we came to LED bulb. What is this? It's nothing but what we are doing. We are improving over the technology because we know the bulb's electrical energy, but we are doing improvement over the technology to get better, cheaper products or the products which are getting the less electricity consumed so that we can be benefited. So this is utilize the published patent specification. If you are doing any project or giving any project to students or doing research, utilize the published patents, read it as a prior art or prior literature survey and go for the further development research, which is good and novel inventive. Transfer the invention as a public property after expiry of term or session of patent. It means after 20 years of the patent term, your patent will become a public property so that anyone can use and again do R&D and improve your product further, better and cheaper. Providing exclusive reward as exclusive right for a disclosure. You have to disclose everything detail. It's not like that. You are disclosing everything invention, but you are not displaying some steps which are giving you good product. That is not correct. And that is not allowed by the government of India while filing the patent application because you have to give good examples, best examples with a detailed disclosure of your invention so that any person who is skilled in the art after completion of your 20 years of your time when it's in public property, then anyone can follow your research simply by following your steps, what you have done during your research. Therefore, it is must that you should give a exclusive full disclosure in the patent application. Make profit by royalty through putting the invention into practice. Once you are getting your invention, that may product or a process, you can earn like anything putting the products or by giving the license. For example, you are coming with a new cement already which is there in the market, which is having more, much better property as compared to the existing cement, then anyone can buy it and you can get royalty. If you are making a good machine which can crush stones of very smaller size as the machines which are there in that, then you can, for the construction feature of that machine, you can get in patent for the technology which you are developing. For example, we are saying that many joint air company has doing the many products which are used in the agriculture industry. What is that? There is nothing that earlier the machines which are wrapping the food or wrapping the threshing the food grains are not available, but now we are doing everything scientifically. That is nothing but we are doing improvement over the technology which is there in the market. Royalty on technology transfer and licensing. You can get for any patents once you are transferring or licensing, you will get royalty on that. This is the importance of your intellectual property rights. Now we'll come to what is patents. Exclusive monopoly privilege right granted by government to the patentee. What is exclusive monopoly? Because it is given to you only. It is monopoly. You can decide whom you want to give license, or solely you want to practice, or what you want to. That is why it's called an exclusive monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing or priority for a commercial gain in consideration of full disclosure of his invention as a territorial right, not worldwide. So, government is giving this right that you are doing something new which is not there in the market or in the public domain. For 20 years, you can enjoy the right how much you want to license or produce yourself, and only that is territorially, because you are filing in India, you are getting the patents valid only in India. If you want the same patent if you file, you can file within 12 months to the PCT and then choose the countries like Japan, Thailand, Bangkok, and many other countries where you are interested or where your market is there, depend upon the survey of your product in which kind you are done in invention. Therefore, the patents plays an important role. What is the invention and discovery? Many teaching faculties, students, professors will very confusing that what is meant by exactly invention is. Here, finding or exploring something which is already existing in nature, and discovery has no technical effort. For example, we are isolating some metals from the earth by digging or doing something by using technologies. That is nothing but an discovery, because metal was already there, just you are isolating by using some methods. But the process or the process parameters or the method what you are developing or designing to isolate that metal is an patentable, because it is a process which you are designing on your own by modification of some techniques. There is a patentable, wherein as such metal is not patentable. Another example, again, in the field of biological sciences, there are cement industry. Many industry effluents will have some bacteria which are alcoholic, acidophilic, or temperature resistant. That bacteria are there in the effluents. If I'm isolating by designing some change in the pressure, pH, or MS media for isolating the bacteria, that is parameters and the method of isolation of bacteria is patentable. But as such bacteria, which are just isolating from the effluents of cement industry, jute industry, or chemical industry, is not patentable, because they are already in the nature, just you are isolating. But if you are doing something genetically changing or biological sequence changing and changing the genetically modified organism, that is different issue. Therefore, discovery means something you are isolating from the nature which is there and it does not have a technical effect. Wherein the inventions are something new, novel, and it should be not be obvious to a person skilled in the art. What is invention means? A new product or a process, useful, novel, and non-obvious, not public knowledge before filing it. It should be new means everyone knows that it should not be in the prior art. It should not be in public domain before the date of filing of your papers. While you are filing your paper publication, we say it should not be in the literature survey and you are filing the paper, then it will be published. Same way. But it should be useful and novel. What is non-obvious? For example, I am cooking the vegetables in the cooker. I'll put the water. Why? It's very obvious to know that if I'm not putting water, it will burn off. But the invention is it should not be no, it should not be obvious to a person skill in that. It means, for example, you are in the field of engineering. If somebody is adding gypsum to a cement, something to increase more bonding, then it's very common, because we are seeing in the literature survey that C can be added. So it should not be obvious to a person, means it should not be obvious without doing any experiment. It should not come to a person who is in skill in the art also. Therefore, it's patent invention means it should be new, novel, and it should be inventive. It should fulfill three criteria. Then your subject matter or your project will be granted a patent. How to achieve an invention? While carried out research or a project, identify some problem. whatever in the field of, if you are civil engineering, electronic, electrical engineering, just see the problems what was there. To solve the problem, what are the there you have to do? You have to study the literature survey, then come to a solution by changing the parameters and solve that problem. That is nothing but your invention because it was not there. I will show you very simple inventions. You might have not thought that it's an invention also, but they have got patent for that. Therefore, always any problem if you're solving, that is an invention and you can solve. At present, COVID problem, somebody come with a biotechnology or be biotech fellow with the composition of COVID, or if any somebody with a medical biotechnology students come with a device which can easily detects the presence of COVID virus antigen in the body is also patentable because easily detectable. So something is not in the nature, something not in the public domain, you're doing something new that can be patented. So before you go start your research, you see the problem for what you want to give the solution, then apply for the patent. It's a very simple example. Nobody thought that sharpener is patented. But in the year 1822, wherein tool for sharpening a pencil, writing point by saving away its own surface was invented by C.A. Boucher from the Paris, and he has got patent, enjoyed. He is right, and now anybody can manufacture because it is now in public domain. So you might have got benefited or may not, a different issue, but this is simple technology, but he has got patent for that. Electric light bulb is and perhaps one of the most famous patent invention known to humankind. It was awarded to Thomas Alva Edison in the year 1878. But now we see tube light came, LED bulbs came. So how much version we are getting and that is cheaper as compared to other. That is what they are doing. They are improving over the technology which is there. You can apply for that also and you can benefit it by getting the patents for that. The first telephone was invented and patented by the Alexander Graham Bell in the year 1876. But what was the drawback of this telephone? 10 times, if you want to connect our dear ones, 10 times you have to ring the number so that you are used to connect the number. But now, next phone came with the cord where we can dial the numbers by putting the 1, 2, 3, 4 like that. Again, next phone came with the cordless, wherein we can take from kitchen to drawing room, dining room, hall, all those things. Again, there was a problem wherein we cannot carry in our jibs, we cannot attend the meeting, we cannot take the traveling. Then again, mobile came. What is this? This is improvement for the technology and solving the problems which are there in the humankind or in the society. So now we are getting different kind of mobile with the different megapixel cameras. What is this? Earlier only we used to take photos. Now we are taking video calling. Our technology has improved a lot. Where you are sitting in Coimbatore, I am sitting here, and we are discussing the topics wherein and talking with each other. That is called nothing but an improvement in the technologies, and they are getting the patent for that. It is not always that something should be new because telephone was already existing, but we are getting patent for the Samsung mobile, Nokia mobile, Oppo mobile, many other things which are there, and many other products we are getting in the market. Bluetooth up to 1994 means how much year over. Before that, we are not having option to this data transfer, but Jeff Hudson has invented Bluetooth in 90. He has got patent for that. So this is an invention in 1994 means when I was in uh, 8, 9, 10s like that so many. So this up to this year also the Bluetooth was not there. Therefore, anything what they are doing which is not in the market or not in the literature survey or not in the public is patented if it is a new and novel. What most common mistakes by the innovators is they publish their invention before filing the patent application. When I was the research student, I was not knowing about the filing the patent application. Our guide used to say publish the patent in international journals, but nobody has told us first file the patent, then you can. Dr. APJ Abdul Kalam, when visited to Gulbarga University, he asked how many patents you have filed for well-known professors. They are quiet because they were just published 101 international papers, 200 like that, but nobody has filed the patent for that in the year 2002. So this is the way nowadays people are at least filing and they are knowing about what is intellectual property rights. So don't publish first if it has a value, then go for the patent filing, then you publish or disclose in your conferences. Use of the invention in public or commercial use of the invention in public or even in secrecy prior to filing patent application. Maintain the secrecy until you file the patent application. Wait until the invention is fully developed for commercial working before applying for patent. If you are thinking it is feasible or may not, if you are having doubt, then wait till your work complete and then you can decide if it is having worth value, that useful, then you can file patent for that. Otherwise, you can you the patent application. Comes to next property, that is design. Design means a shape, configuration, pattern, or ornament, or a composition of lines or color combination thereof applied to any article or in the form of 2D or 3D or in the both forms. Means any design which may be beautifying, that is registrable. हॅलो, मी लेक्चर मध्ये आहे. हा, मी लेक्चर मध्ये आहे म्हटलं. Design applicable to the eyes, beautifying and product attract to consumer, mere functional or technical feature of the article are not considered as a design because only it's a beautifying. This is a couple of sets where you can apply the design and you can get protected. The term of design is 10 years and can be extended for 5 years, and total 15 years you can enjoy the right of the new design which you are registering in the offices. This different kind of design. These are pharmaceutical designs. These are all registered. You can come to textile designs. So anything beautifying that jewelries, that design can be registered and it can be sold by licensing. Now, what is trademark or brand name? Visual symbol, which may be a word, name, symbol, or a brand, or numerical or combination of colors to indicate the source of the goods, to distinguish from the goods of the others. That is called authenticity of goods. This is called a trademark. Reliance, Tata, Bata, Coca-Cola, Britannia. These are the marks which are already registered. R with the encircle is a registered one, and the only R what they indicate, that is the trademark applied but it not granted. It advertises goods and services, protect the innocent public from buying the goods of the second-rate quality. R is registered trademark, TM trademarks applied, and duration of registration of trademark is 10 years. It can be renewed every 10 years subject to the use. You can, how much you want to use, you can extend by finding the renewal fees and you can use still. Once for example, any startup you are starting, any business you are doing, any office you are opening, keep the name or register or mark so that once it becomes famous, no one will copy your mark or whatever your business you are doing in that. You can see many water bottles we are having TM or R registered in the particular name, like many other things in many people nowadays. If you are opening the shop also, Pizza Huts also, they are having names with a registered one. Therefore, it should not become competition in their own business or in the market. What is geographical indication? Its place names used to identify the source of origin, quality, reputation, or other characteristics of the products. Example, dazzling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges, and term of protection 10 years and can be renewed every subject to uses. Here, in case of geographical indication, a group of people has to register their origin. For example, Nagpur oranges is a farmers group of Nagpur people have registered this. Kanchipuram silk sari is the people of Kanchipuram in group, they have registered this for the geographical indication. Wherein other rights like trademark, patents, and designs, individual can register, company can register, or both combined they can register. Wherein GI is registered by the group of people or associations of the people who are working in the same are supposed to register as a GI. What is copyright? Provides its holders the right to restrict unauthorized copying, reproduction of an original expression, literary work, movie, music, painting, software, and the term of protection is granted in life of the author plus 60 years. We see many books which are written by the authors, many songs sung by the singers. They are getting the royalty still because life of the author plus 60 years they are getting the royalty for that wherein the copyright has been granted. This is a simple differentiation way from the patents, design, copyrights, and trademark. This is a technology wherein patent is for technology, novel, inventive, industrial application, and term is 20 years. This is a wherein pressure, where indicates this is a technology. Wherein the design, different designs of different mobiles is for the design. Tata Bata business is the trademarks wherein the life is 10 years and the author book for books is 10 years. Life of the author plus 60 years for the copyrights. Wherein GI is 10 years and it can be renewed for the year 10. This is a differentiating feature to make you the more understanding about the difference between the different intellectual property rights. Now, how the different intellectual property rights are interlinked with each other. Example, the Sony TVs be very common because earlier when we are young, we are students of 6th to 8th standard, there Sony was very famous for the clarity, sound. The trademark Sony can be protected and also they have protected and earned like anything. Invention on remote control mechanism can be protected by the patent. Design is the aesthetic view of the TV set can be protected by design. And the instruction which are given in the manual of the TV in the box are copyrighted. So single product TV is protected by the different intellectual property rights so that other competitor will not copy the technology, nor name, nor its instruction, nor its design. Therefore, it is protected by different intellectual property rights. This pizza is a very famous example, commonly easily known. Trade secret is the ingredient which are added in the pizza so that it increases the taste. Many people will prepare the idli chutney, sambar chutney, but some chutneys are different from different to different. What is that? Something they are adding to get a better, good quality of the chutneys. That is trade secret. We are not knowing, but commonly chutneys we know by YouTube, we know, and we'll do prepare like that. Same way, here in pizzas, to enhance the taste, from Domino's to some other pizzas are different in taste because of their trade secret. Trade secret is made by agreement between the people or who works in the kitchen of the pizzas. And trademark is the Pizza Hut is the name given is that trademark. Industrial design is the design how the pizza is being made. Patent is for technology of making the dough or the machine which is used for making a must good dough which is fluffy. And the instruction which and the name which is given is that copyrighted. A single product can be protected by more than different kind of it. Means your trade secret is protected, trademark is protected, design also protected, and the copyright also for the instruction which are used for the pizza box or inside the box what they are giving. It's a different kind of here trademark trade secret is not related. Trademark for the Tata for the Sony, Samsung, Nokia, Oppo. Design is different design for different mobiles. You can see by holding your own mobile in hand with compared to your colleagues with other phones. Patent is for the technology, the how much megapixel camera. That is combination of hardware with the software is protected by patents. And copyright the instruction which are there in the box of the mobile. So intellectual property very much essential so that your computer will not copy your instruction or technology to produce their goods. This also here in relation to the IPR, here trade secret will not be there, but the trademark which is applied on the your morning walk shoes, design how it is made, and technology of the textile what they are using is for the patents and the instruction of the shoes are copyright. So we can protect different whatever the product you can. What is the benefit by knowing the intellectual property rights? Patent file or other IPR, become a patent agent if you are a science graduate. Once in a year, our office will conduct an examination that is called patent agent examination. Any science graduate can apply for that. If you qualify that examination, you can become facilitated between inventor, company with the government of office. Become a trademark agent if you are a copyright agent, if you are a law graduate. You can, by knowing IPR, you can work in the IPR policy for the students. They can work in the IPR cell. They can work as NGOs wherein they can facilitate to the government of India to the individuals who are doing new things, patents, design, trademark. They can work in different IPR firms that are found in Chennai, Delhi, Kolkata, Mumbai, and they can join even in the government office. Any B fellow can write our exams for the patent examiner. If they qualify, they'll get the job. This is the opportunity of IPR for the students who are listening my lectures. Thousands of scientists or faculty or students can also be an inventor. By simple approach, they can be file a patent and they will become the inventor. While carry out research projects, identify some problem, solve that problem, apply for patent. Always don't forget to take non-disclosure agreement with your lab colleagues, students, or lab mates who are working with you. Always try to take non-disclosure agreement and take the sign of them so that your invention will not be disclosed anywhere else and on your own other than your colleagues or your researchers who are with you. What are the right of patent is? It can manufacture and selling, preventing others, licensing and cross-licensing, assigning to third party, importing the patent products, improve for further R&D. What is patentable criteria in India? Invention is new, product or process not been disclosed in the prior art. It means it is not in the public domain or prior literature survey. What is prior art means? Everything that has been published or presented or otherwise disclosed to the public before the date of filing of the complete application. Before the filing of the patent, we see that is it filed in India or not, or else in the world. Because we see the literature survey even in while publication the patent application. Therefore, always check whether it is published, presented, or disclosed anywhere before the date of filing of the complete application. What is inventive step? A feature of invention or technical advancement compared to the existing knowledge or economic significance or both that makes invention not obvious to a person skilling that. For example, the process of preparation of beverages from food grains. Already there are many processes which can prepare beverages from food grains or fruits or many other molasses like that. But if you are using 1 ton of your raw material and getting very less product, and now you are designing a process which can give 99% purity with a 99% more product, then that is economically significance. You are changing the process parameters, chemicals or catalysts and bringing something new or improvement over the technology, then that is patentable. Any machine if you are doing which can give 100% yield or by putting the 100% putting your 100% raw material, that is also good one because many things sometimes in preparation of medicines we are putting 1 quintal of raw material, we are getting less product as outcome because some will waste or some will go as a other by means of other sources. Therefore, if you are designing a new process which is very good, efficient by changing the parameters, then that is nothing but you are doing economically significance and you are earning. In case of cost also, if you are presenting 1 quintal of raw material, if your earlier cost was from 10,000, now you are doing in rupees 1,000 only, that is nothing but you are doing new process for a economically significance. Therefore, always if you are filing the invention, it should be novel, inventive, and should have a technically advanced process. What is the indications of non-obesity? It should have surprising result. For example, if I am taking paracetamol, it takes 8 hours to reduce the fever. If somebody comes with a new composition of paracetamol and I'm getting fever reduced by 2 hours, that is something surprising. If I'm getting earlier product is of 50% yield, now I'm getting 99% yield, that is something surprising result I'm getting from new process. Therefore, this is not non-obese. Solution to a long-standing problem. For example, if some problem in the nature, then if you are finding the solution, that is nothing but a new invention. Fulfillment of a long felt need. If you are something in need and you still not Then, if you are doing the solution or you must that machine process, that is nothing invention. I told you gas problem. Using for cooking gas, if you are bringing a cylinder knob for a cylinder which can indicate how much gas is remaining, that is solution for the long pending problem which is daily commonly used by the common man. So that is solution, and you can file, that is technology, you can file for the patent. Great technical progress. If something you are doing and that is great technical process, that can be patented. Now, there are two kind of applications, that is specification we call in the case of patents, provisional specification and complete specification. Provisional means once the idea comes to your mind, you are filing the application as soon as the idea comes. That is a provisional application. Complete means you are completing all the resource with the examples and the claims. That is complete specification. What is the advantage of provisional specification? Should be filed as soon as inventive idea comes in mind, shall contain preamble to the following specification, describe the nature of the invention, change in the provisional if possible throughout the post dating of the application. Once you are filing provisional application and you want to change or post date, you can do the same also. Advantage of provisionals are priority for invention, get extra time for further development, disclose the interested person to obtain financial support, explore commercial feasibility, avoid further expenses if no commercial feasibility. For example, once you are filing a provisional application and filing to the UGC or any other forms to support you as a financial support, then you can apply that so and so patent number you will get by applying the patent. Therefore, it is best to file a provisional application. What is the content of complete application? Like our PhD thesis or projects, we should have a title and preamble of the invention. What is prior art? That is research survey, what we are doing, that should be written. What was drawback in the prior art? Detail you have to write. Efforts or solution to drawback means what solutions or what practically you are doing to bring the drawback of that. Again, write the summary of the invention, what it relates to. Then statement of the invention, it should be given. Detailed description of the invention with respect to examples, drawings if any, biological invention sequence if any, then give the reference to drawing, then examples, and finally claims. This is the whole essential ingredients of the complete application. Once if you want to file a patent application, it should have all the contents what I have told you regarding the contents. Main conditions for this is description should state in the clear and intelligent language about the invention so that others may know about monopoly or patent. Means what do you want to protection? That should be known by the others. Therefore, it should be clearly, concisely written. Should disclose the manner in which invention is to perform so that others may know how to repeat the invention when the patent expires, how to carry out the new invention without doing further experimentation. Once your invention expires, other person can try it without any difficulty. Therefore, you are supposed to give clear examples, what you are using, and clear steps of your invention in the application. How the claim should be. Every complete specification shall end with the claims or claim defining the scope of the invention for which protection is claimed as per section 10(4)(c) of the Act. The objective of the claim is to define clearly, precisely the exclusive rights required for you. Define the scope of the invention. Define the various necessary, preferred, and optional feature of the invention to limit and not to extend the monopoly being granted beyond the inventive field. Means where your invention lies, that you have to cover so that you will be get protected and other will not copy or other will not pass your invention if you are not covering properly. Always claim should be fairly based on the matter disclosed in the specification. If your invention is on cement, claim should be on cement. If your the invention is on process of breaking stones by smaller size with the machine parameters, then with the same. And the first claim is always called principal claim, and subsequent claims called subordinate claims, and should define all the interconnections or preferred embodiments of the your invention. Therefore, so that examiner who sit in the government of India can easily understand where is the invention lies, and he easily find out what is in the prior art and how you are arrived at invention. so that he easily judge your novel, inventive feature of your invention and grant the patent for you. There are different kind of claims. One is called independent claims. Process of preparation of cyclosporine or a process of preparing cement is a one type of. Another is a dependent claim is a process as claimant wherein gypsum is used in so and so percent. The process as claim one wherein the brick material is used in so and so percent. These are the dependent claims. So one is called independent claim where defining all the process. Other subordinate claims are dependent claims wherein you are giving the essential feature which describing the main claim, that is referring to the preceding claims. Therefore, it is a dependent and independent claims. One example I will give how to write an application or complete specification. Example is foldable pen. Very easy example. You can see your pens which are there in the zip or your in the pockets. You can take in the hand. You can see ours is different pen and foldable pen is different. How it is there? Is a drawing of the pen. While filing the drawing, you have to tell how many total sheets of drawing and the sheet number is. You have to number each drawing, each content, each part of the pen so that in the description you can write what that part is. You can refer to drawing 1, 2, 3, 4, whatever may be. And lastly, applicant and signature. This is another drawing wherein other number is also given. This is the specification where writing is title is foldable pen, applicant so and so, nationality is Indian, and the following specification particularly describe the nature of the invention and the manner in which it is to be performed. Means he is giving detailed description for which he has written the complete application. These are the field of the invention. Field, what is the field? The present invention is a foldable pen, which lies flat when it is not being used for writing and can be used as a bookmark when unfolded. So, he is giving background of the invention, how the earlier pen was. Pens of the state of the art have a barrel, which are generally either a circular, hexagonal, or triangular, means and cross-sectional shape. He is telling in background what are the different kind of pens, how they looks, and the disadvantage of the their thickness and shape. He is telling the disadvantage of the other pens which are there before the filing of this application. Again, he is telling the disadvantages of all these things. Then again, he is telling summary of the invention, what exactly he is done with the present application. He is telling the invention comprises a pen, preferably made by injection molding, whose barrel is made up of 3 flat panels. One of the panels is connected by the first hinge on one side to the second panel, and the third panel is connected by the second hinge to the opposite side of the first one, so that single plane is formed by the 3 panels. He is telling this pen is of 3 panels. So he is telling describe the pens, and these are the advantages over the pens which are there in the literature survey. Now he is giving the statement of the invention is foldable pen. It has flat body of quadrilateral shape, molded to form 2 longitudinal depressions in the side body. Side depressions acting as hinges and defining 3 panels such that the body may assume to distinct shape either virtually, a flat quadrant, or folded like a prism. And also this pen has a hollow reservoir located for the ink. Again, it has part that is called writing tip also. It means has 3 body parts A, B, C. He is telling all details. Now he is giving difference, brief description of the component drawing. Even he is telling what is drawing 1, what is drawing 2, drawing 3. Figure 1 is a perspective view showing the pen when it is flat. Figure 2 is a perspective view showing pen being grasped by the hand. And 3 is a section along plane 3 to 4. Means he is telling each and how they are interlinked. He is telling again in figure that is detailed description of the invention. That is figure 1 is comprised of 3 panels, 1, 2, 3. With the first panel, 1 is being attached to the second panel and the third panel. Means how the attachment of the pen means constructional feature of the pen he is describing in the detailed invention. Now first panel 1 has hollow reservoir, number is 7, storing fine, dispersing the ink, writing tip 8, such as ballpoint tip or felt type, through the which the ink will be dispensed extended into the hollow reservoir at the tapered end of the first panel 1. At the end of the first panel 1, opposite to the location of the pen, the tip 820 means he is telling all the description of pen, how it is there, how reservoir is there, how it dispenses the ink, and how it comes to the tip of the pen and write down its help in writing. Figure 2 is each figure is describing easily so that any person who reads will easily follow. Lastly, he is claiming the claim how his pen is. Pen is having a foldable pen comprising means it's having many parts again. A flat body it has, hollow result it has, rating tip it has. Claim 2 is a foldable pen as claimant wherein each panel is of the same size. Means pen is not big and all, it is of same size. Foldable pen as claimant wherein each edge is of the pen is beveled. What type of it is? Beveled. So he is telling each content of pen or description of the pen how it is. A foldable pen, as claimed in claim 2 or 3, wherein each panel is tapered and folded construction forms a truncated pyramid. He is telling how the pen is. Then again, claim 5 reservoir has having venting or fives opening into the hollow reservoir. Foldable pen as claimed wherein the pen tip is a ballpoint tip. He is telling all the parts how it is. Foldable pen as claimed wherein the pen tip is a felt tip. Foldable files you describe with the drawing also. Date and signature is a must for the applicant, or if you are filing through patent agent, then he has to sign the end of the complete application. Another I will give you Ayurvedic formulation. There is a one invention wherein Ayurvedic formulations for treating a Parkinson disease. We know we are having allopathy disease, but why yes came to Ayurvedic? Because allopathy has many side effects, and those are gastrointestinal side effects, nausea, anorexia, cardiac. Therefore, he is telling that I am doing a new Ayurvedic formulation for treating a Parkinson's disease. What is the main objective of his? He is giving it cheaper in comparison to the existing drug, therapeutically active and clinical, and having no side effects. He is telling. Another object he is telling that plant-based Ayurvedic formulation easily and it can be used as a tonic. Another object is that this invention is to provide plant-based Ayurvedic formulation which is readily soluble in water, delicious and flavorous. He is telling it is soluble in water and it is flavorous. It is very eager to consume so that it is flavorous. He is telling advantage of this case. Now, what is the main plant here is he is selecting the ripened seeds from the Mucuna purens bark, Atmagandha valvent plant, polarizing seeds and mixing the seeds with 80 to 90% with the formulation 20 to 10% by other like vitamin C, antioxidant and stabilizers. Means he's telling I am giving the Ayurvedic formulation which is good and which has also vitamin C and E which is useful for the body and it should not have it is not having any side effects. So this is the one of the invention and the claims how it is the process of preparation of plant-based Ayurvedic formulation for the treatment of Parkinson disease comprising the following steps: selecting ripened seeds, polarizing, mixing, and preparing this. These are the steps wherein applied for. Exact content seed powder is 90%, antioxidant is 5%, stabilizer is 5%, and the process with the vitamin C and D. So this is the way of drafting the claims or application wherein you are doing the research. Another example, I give you the gypsum cement and method of making the same. It is a US file patent application. Patent number is 1973473. The method of producing an accelerated gypsum cement, which consists in mixing finely divided crystalline precipitated calcium sulfate with a relatively small amount of plaster of Paris in the presence of small amount of water in pelletizing and in exposing heat or high temperature. So he's making a gypsum cement by doing this. So this is the patent application. The method of producing an accelerated gypsum cement, which consists of mixing precipitated calcium sulfate with a relatively small amount of plaster of Paris in a moisturizing with water and agitation to produce pellets and exposing to heat of a high temperature. Means what he is doing? He is preparing gypsum cement by some method and he is telling what is exactly he is adding and what he is doing. So this is the patent which is granted in the US. Another example is a gypsum cement system for construction of materials, that is Canadian CA number, this is a patent number, a composition for use in construction material which may be substitute for high performance concentrate patching material, joint compounds and the like such as backers boards or panels which include setable calcium sulfate, preferably hemihydrate, Portland cement, a finely divided pozzolanic material, aggregate optional including other additives, the volume ratio of the aggregate to the combined calcium sulfate, Portland cement. These are the content of his composition which are used for the construction. So you can also do the composition for the cement having different ingredients which are not in the literature survey, and you can file the patent and you can earn by giving the royalty by giving the your composition to the cement producing companies. Another simple example is that dog umbrella. We take our pets to the outside for walking. And once the rain comes, we rush under the tree or we see the sunsets. But there is technology for already done by Anthony in US, and he got patent for that. It's an umbrella which can protect your pets from the rain. Another example is that how simple but they are earning, so we never think of doing the patents. Dog waste catcher and holder. It's carries by dog's owner to caretaker while he was or she walks the dog. As soon as the dog shows the motion to excrete, this device can be placed under the dog's bottom and catches the waste in the plastic bags and at the place. Once the dog has finished, the plastic bag is removed and discarded. This is a very simple and sanitary way of catching and discarding the dog waste. But our Indian mentality, our house should not be polluted and we'll bring them on the road, but we never carry this type. This is a technology where its patent has been granted to it. Enhanced fish attractive device. We know we are of many people, we are having seashore side people, we rivers and many instances since long back our many people catches fish but still through net only. But Brookoff's Gray has invented a device wherein fish can be catched by a new way. That is, this is a machine which he has invented, and it is called enhanced fish attractive for device. Means still Indian mentality never thought of. We are since long back we are catching the fish, but nobody thought that some other way to catch the fish except net. But still we are following the net system. Even Karnataka, Tamil Nadu, even Mumbai side also people who are there seashore, even Tamil Nadu also the people who are seashore and where their business or their day livelihood depend upon the catching the fish and selling the fishes. So these are the technologies. Still, we are not dull for we never think of patenting. Just we go for the publications. How to file it? You know the how to what is patent, design, trademark. How to write also know how to file a patent application. Any person, individual or natural person can file. Legal entity can file. Small startup can file, and jointly you can file with any of them. You can file physically go by visiting the parent office. As your jurisdiction comes to the Chennai, you can go and file. Or by sitting in the home or in the office, you can file electronically. We have given opportunity since July 2007 to file an online application. These are the different jurisdictions. Mumbai covers state of Gujarat, Maharashtra. Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and all. New Delhi covers state of Haryana. These are the jurisdictions which we are supposed to file the patent application. What are the minimum requirements for filing the patent application? It requires covering letter, Form 1 for indicating the details of application, title, applicant details. If you are hiring agent, type of application, you have to write all the details in Form 1. Proof of right to apply for the patent, provisional or complete application, Form 2 is required. Statement of foreign filing, if you have filed for an application, then you are supposed to give in Form 3 undertaking. Declaration as to inventorship, that is Form 5. For example, while you are publishing the papers, we write our inventor's name, our lab mates. Same way, if you want to give more inventor's name, you can file Form 5. Request for examination, that is on Form 18. Drawings, if any. If you are a mechanical engineer, civil, you can give drawings. If biological invention, then they can go sequence listing or biological material. Then you have to give 150 words abstract of your invention. Fees in the form of check or DD if you are filing physically. If you are filing online, you can file through a apps online with a digital signature. Optional are, if you want early publication, the request for filing Form 9, where they get requested. If you are going through attorney or patent agents, Form 26 required. If you are filing a PCT application or convention application, certified copy of the prior document is required for filing the patent application. These are the fees for natural person 1,600 and 8,000 for other no small entity, because since since October 20, we have made a common fees for even small entities and natural person, that's 1,600, and for others 8,000. That is up to 30 pages of your application. Once you cross more than 30 pages, each page require 160. For each claim required, 320 for the individual and the company 800. This is a fee. If you are filing a hard copy, that is, there will be 10% of the additional fees over the fees mentioned above. And you can get all the fees details in the website. No need to write down because these fees are given on the website. And if you're just in the Google also, you'll get detail how much you are supposed to pay fees for individuals and the company. How the documents of the patents while filing. It should be Hindi or English. All documents should be on A4 size sheets, large and legible characters, not less than 1.5 spaced. Margin should be of at least 4 centimeters given. Numbering at every fifth line, that is C rule 9 of the patent rules, and prepare your draft file, application to file your patent application in India. If you are requesting for Form 18, 4,000 for natural person, there is no question of small entity now. 20,000 for the other than the natural person for filing the request for examination. Once you are your file application, you are must to file a Form 18. Otherwise, if you are not filing request for examination, it is treated as a withdrawn by the applicant. Form 9 fees is for individual 2,500 and for company 12,500 if you want to express publication. This is the way we publish documents: application number, date, title of the invention, name of the inventors, company name, and the abstract wherein, and the international classification. These are the ones published. You will come to know, or any person will come to know, it is published on anyone and what type of invention is. And then, if anybody want to oppose, they will oppose the application. Publication under section 11A, there are except amendment, they will not publish others. If you want expedite examinations, early examination, then Form 18A you are supposed to file, or while filing PCT, if India as a ISA, IP, ISA means International Searching Authority, IPM is International Preliminary Exam Authority, if you are choosing, or applicant is a startup as per the rule 2019, one of the applicant can be ladies, then you can file expert examination, or government organization and institute can file a expedite examination, means early examination. For individual 8,000, for company it is 60,000 fees for early examination, that is expedite examination Form 18A. These are various forms can download or you can see in the our website www.ipindia.nic.in. Online can be filed or you can file even offline. If you want to file online, you have to follow this and log in and create your password, and you should have a digital signature for that. What is the procedure for granting and how from funding? Once you file a patent application, it will go for digitization, screening and classification based on the subject matter, because we are having auto or admin system based on the electronic, mechanical, electrical, and biotechnological fields. It goes to the particular examiner who is belong to the particular field. Therefore, screening and classification must. Then, if you are requesting for early publication, we publish within week or within month. Otherwise, we wait for 18 months for publication. Then, request for examination comes. Then it's go for examination. Once published, any pre-grant application filed by any person can oppose the application. These are already in the literature survey or copied from me, and he can write to the Government of India, to the controller, and we will take the hearing and they will decide on the basis of merit whether it is really in the public domain or not. We will decide that and we grant or refuse the patent. Once the examination start, examiner of FER, first exam report will be sent to the applicant or applicant agent. If you filing through the agent, then you are supposed to reply or objection within 6 months. If you are not able to meet 6 months, you can take extension of 3 months. Then again, depend upon your answers to the questions, it may be granted or refused. Once granted, then again it's go for the post-grant publication. Then anyone can file, their interested person can again file in opposition. Means once you are filing an post-grant opposition, then again hearing portion takes, both the parties will be called to the hearing, depend upon the merits, and demerits will decide grant or refuse the application. Once the ground oppositions are not correct, then we'll go for grant. If opposition grounds are true, then it's be rejected. This is decision given by the controller. This is a way of granting the patents. These are different patent databases you can go through before starting your project or thesis or any work. You can go to IP India, Google Patents, EPO Patent, USO Patent, or WIPO Patent. You can search there by putting your topic before start your research, what is there in the literature survey, so that you can modify your research and do further research so that you can come to a conclusion of novel and inventive product or a process. These are the fees which is there available in the website. No need to explain by each one. Farmer know how much fees for individual and company. What is the role of intellectual property system? Encourage for improvement of technology, provide reward as an exclusive right for disclosure, making profit or earning royalty through the putting the invention into practice, transferring into public property after expiry of term or cession of the patents, right of properties to prevent others from making and using, a process offering for sale, selling, importing for those purpose product obtained directly from that process in India. Who can use freely or patent? Government for the purpose of merely of its own use as per section 47 or for experiment and research purpose only government can use this work. Term of patent is 20 years from the date of filing of the application. By knowing all intellectual property, patents, design, trademark and geographic indications and copyrights, what to do now? Suggestions to the others say the benefit of patent system to everyone in community, in classroom or with the others. Utilize the resource through the organized R&D activities, capture the global market judicially, earn profit through the putting the innovation into the market or putting it into practice. Thank you. Now I rest my lecture here. Now session is you can ask questions for me.
Thank you, sir. Very informative, sir. The
Yeah.
participants are registered to post the queries in chat box.
Okay. Chat box, no?
Participants, please post the queries in chat box.
Yeah, I see anyone has detail. Yeah, somebody asked me share the PPT. Okay.
Yes, sir.
As we are the authority who's telling about the copyright, we cannot share the slides because it is copyrighted one. If they want, they can take my email, they can take my contact, and they can ask any doubts of patent, design, trademark, and I am here to clear their doubts while filing or doing the research. Okay.
Okay, sir.
Many of them should kindly send PPT only. Everyone has requested PPT, but our organization, being a government of India, not allowed to share the PPT as it is a copyright material.
Sir, one question from my side, sir.
Yeah,
How long is a patent valid, sir?
20 years from the date of filing. Once you are filing, 20 years you can enjoy the right of patents.
Okay, sir. Sir, how do I protect my idea without patent, sir? Any method is available, sir?
No, not idea. How can you patent it without patent? No, because your idea somebody are disclosing, they will go and copy. Then what is the proof that they have copied from you?
Okay, sir. Okay.
So it is idea is not patent. Once your idea, it means you cannot say. If I can trade secret, you can by disclosing or taking the agreement from your family members. If you are disclosing in family, you can take. But what about the idea? Once you share, it is gone. You cannot protect it
Okay, sir.
because there is no proof in the court to prove that it is my idea only. He is copied from me because I shared on so and so date to him. This is what is proof there. Nothing proof. So you
Okay.
cannot protect your idea.
Okay, sir.
Yeah. There are many questions coming. 1 minute. Service business can be patented.
Yes, sir.
Feedback forms. I have one question. Suppose I have published the thesis paper recently. Someone told me even though you can publish 6 months, 1 year, till you can be fine. Yes, somebody asked me a question that he has published a patent a paper 6 months back. So can he file a patent? Yes. Once you publish your patent within 1 year from the date of publication, you can file a patent application. No problem at all. Is there another question mm, is that true or paper should not be published? No. Oh, within year you can file. Always file the patent, then you can disclose or go to the conference and disclose. Anyone, any questions?
Any questions?
No, business method is not patented. Business method is not patented.
Okay, sir.
Any other question? Service business can.
Good evening, sir.
Ma'am, so 44.
Hello. Good evening, ma'am.
Yeah.
I have a doubt, sir.
Yes, you can, ma'am.
Yes, sir. What is the procedure for get patent for a new equation, sir?
Equations, that is mathematical method is not patented. C section, uh, software assets is not patentable. Section 3 of the Patent Act, you can check in Google. There are some equations are not patented.
Okay, sir.
Method of printing
Someone
information is also not patented.
have their patents, sir. Really, I have gone seen in the Google. I have
Uh,
referred so many journals. The
uh,
equation name was Kumuta equation. They have put it like that, sir. How can they?
but in India, patent the equations in India is not patentable. Method of surgical is not patented. Method of business is not patented. Software assets is not patented. There is law is different from country to country. Even vaccination is method of vaccination is not patentable. Vaccine is patentable, but method of vaccination is not patentable. Method of cleaning teeth, method of vaccination. These are some treating method. Agriculture methods are not patentable. These are the depend upon country to country.
Okay, sir. But they put it the name itself before the equation, sir.
No,
How?
you can get copyright for the equations, ma'am. If it's new, you can get copyright for that.
Okay, okay. That it's a copyright. Okay, okay,
Yeah,
sir.
yeah, it's copyright material. You can get
Thank you so much.
protection and you can get royalty for that if you have any new equations you are getting it on.
How can we do it, sir? How can we do it the copyright, sir?
You can write www.copyright.gov.in. They have given forms. You fill it. You can fill online or
Okay.
by
Yes.
speed simple 500 rupees per application fees there. Okay, ma'am. Hello.
Sir. Hi, sir. Hello.
Tell me, ma'am. Pardon me. Yeah. Please tell me.
To prove that the equation, and then only we have to got the patent, sir. Sorry, copyright.
Yeah, yeah. What is writing? Yeah, yeah, yeah. Yes, yes. You have to. You can say it is my own equation, and there is form. Corporate form is there with 500 rupees. You can file. Then they will give me because patent its own
So how can I get the procedure? Sir? In the website itself.
You just go to the w dot okay copyright.gov.
Okay.
Detail they have given. Detail they have given. Detail they have given. If you're
Okay,
not,
sir. Thank you.
you can call me.
Thanks so
You
much.
can call. You can call me personally. I give on your WhatsApp also.
Okay, sir. Okay, sir. Thank you very much for your kind suggestion and advice. Thank you, sir.
Somebody has told me, sir, I write research paper before publication. Someone stolen and published my by their name. Then what I do for this? Once it is published by other name, you cannot do. You have to. It's not patented. Now, if you are filing patent application, they would have told by filing opposition. But in research publication, I don't have idea about how to protect your papers. But the same stolen and filing patent, I would have told you, you can approach for filing a pre-grant opposition. But here, research paper means I don't have idea to save your because somebody stolen means I don't have idea. Okay.
Sir, please post your mail
Good evening,
ID,
sir.
sir. It will be helpful for
Okay.
us,
Okay.
sir.
Yeah. 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 I am giving.
Thank you.
Hello. Hello.
Yes.
Yes, sir. Good evening, sir. I have one small doubt, sir.
Yeah. Yeah. Please.
Yes, sir. Actually, sir, I am doing PhD. Actually, my
Yes.
research is based on product based. I'm working on product
Yes.
based. Sir. So I have a small doubt. What's the difference between patent and industrial design, sir? Because my work is I am working on a bioreactors.
You
So
can. So
so
if
I
you
either have to
I,
go for a patent
yeah.
or either go
If
for
you
the
are bio
industrial design.
if you are designing new bioreactor or what is that?
Yes, I am new
Yes, you
bioreactors,
can
sir.
file it. It is called a mechanical. It is a mechanical patent. You can file it. The construction feature of your reactor. No problem. You can file patent for this product patent. Device patent. It's called, no,
Oh,
design also you can file
patent,
application. That
not
is
for design.
different thing. But for patent, you can file.
particular design we are doing.
Yeah, yeah.
We are
You know, you
checking.
can
We are
separately
found
file.
like
You can file separately design that is aesthetic view to look. But here your reactor means it is a mechanical device which is used
okay,
for the bioreactor. You can file patent for
okay,
this. You can put in Google bioreactor patents. You'll get
okay,
different ideas how to write up the your
okay.
bioreactor application.
So when I have to go, do for design, the industrial design. When I have go for the industrial design.
Anytime once your design is ready, you can go for filing a design because the design can be applied to the any of the four branches and it will be examined in Kolkata office.
Okay, okay, fine, sir. Okay, sir.
The application will be
Thank you,
extended
sir.
in any of the offices. Please detail process to
Oh,
get the digital signature. Digital signature is some. This is not our office work. You have to take digital signature by some methods. I don't know. Somebody asked me. Please detail the process to get the digital signature.
okay.
Hello.
Yes,
Somebody
sir.
asked.
Yes, sir.
May I know who has asked this question?
The question from Anita Karthik.
Yeah, sir. Good evening, sir. Myself, Karthik,
Yeah.
sir. Sir,
Yeah,
actually, I'm
yeah,
Hi,
trying.
sir.
yeah, yeah. Yeah, you can get
Very
the
good evening,
digital.
sir. Actually, myself
Two,
try to
two types of things.
online filing, sir. But the digital signature is some problem arising, sir. So only ask for that
Okay.
question, sir.
Yeah, you can take my mobile number from the organizer and you can call me tomorrow. Okay, I'll solve your
Sure,
problem.
sir. Sir, kindly give your
You can
mobile
take.
number.
Yeah, yeah, 9892. I'll
Sir,
type
just a
it.
minute, sir. Yes, sir. 9892
I 9892 605892.
5892. Yeah, thank you
Yeah,
so much for your.
yeah, I'll solve your doubt tomorrow. Okay,
Sure,
because
sir.
so
Sure.
I
Thank you
had
so
to
much.
ask to IT team, software engineer team become. I am a biotechnologist. I was not aware of that. I just asked the software
Okay,
tech.
sir.
People. Hmm?
Sure, sir. Thank you. Thank you so much, sir.
Yeah, after lunch you can call me. Then any doubts, please.
So, participants, any doubt, please? Any other questions, please? Sir, I think it's over, sir.
Yeah, because I basically started from very small as we people are being highly educated. I started from basic because many IPR people are not knowing. So maybe clear. If you are not clear, you can ask anytime. Okay.
Okay, sir. Thank you.
Thank you so much for everyone for patiently listening my lecture.
Okay, sir. Ma'am, shall I wind up?
Thank you so much, sir. It was very informative and very interesting.
Thank you,
And
ma'am.
you had detailed almost every little bit of intellectual property rights and how to file a patent. I
Okay.
think all the participants will have a lot of takeaways, a lot of input from this webinar, and you had
Yeah.
given an overview of the entire process.
Yes, ma'am.
Thank you so much, sir.
Okay. Thank you.
And thank you, sir.
Okay. Can I leave now?
Subhashri?
Ah, yes, sir. Yes, ma'am.
Yeah, propose
Okay. So, good evening to
the
the.
word of thanks and
Okay, ma'am.
Yeah.
So, good evening to the Honorable Chief Guest and respected CEO, head of various departments, faculty members, and my dear students. On behalf of Hindusthan College of Engineering and Technology, I take this opportunity to propose vote of thanks to those who have directly and indirectly contributed to this webinar on intellectual property rights and patent process organized by our college. I would like to thank the Honorable Chief Guest because today's webinar can be complete without your presence and your valuable thoughts. I thank you from the bottom of my heart. Also, I want to express my heartfelt gratitude to Dr. Bharat and Suryavanshi sir, the Assistant Controller of Patent and Design, the Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. We thank you for sharing your opinion and findings about intellectual property rights and how to apply the patent process, which has given a greater knowledge regarding the field in this present time. And we take this great honor to thank the head of Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, for their kind consent and support for this session. I take this opportunity to express my sincere thanks to our management and respected CEO, Dr. K. Karnagaran sir, for his motivation and encouragement. I would like to thank our HOD ma'am, Dr. K. Agil, for her kind support in all possible ways. And special thanks to the IPR and IAC cell President, Dr. K. Sivas